This is not a drill. What just happened in Washington could fundamentally change federal firearms regulation in the United States, and almost no one outside the gun community is talking about it yet. Congress has just passed a measure that blocks the enforcement of the federal tax registry for suppressors and short-barrel rifles nationwide, and the implications go far beyond a simple tax cut. This isn't a tweak. This isn't a loophole. This is a direct strike at the legal foundation that has held the National Firearms Act together for nearly a century. And now the federal government is scrambling to respond. Before we get into what this means for suppressors, SBRs, current NFA owners, and the future of the registry itself, make sure you're subscribed and notifications are turned on. This situation is evolving fast, and the next few weeks could decide the fate of federal gun registration as we know it. At first glance, the legislation looks almost boring. It wasn't branded as a sweeping Second Amendment reform. It wasn't debated on cable news. It didn't come with dramatic floor speeches or viral sound bites. Instead, it was embedded inside a must-pass federal appropriations package. That includes collecting tax payments, processing Form 1 and Form 4 applications, paying staff to review NFA paperwork, maintaining the federal registry database tied to those taxes. The House passed the measure with 223 votes. The Senate followed with a narrow but decisive 52 to 48 votes. That means bipartisan support, something almost unheard of for any legislation touching firearms. And that's where the story stops being boring, because unlike previous reforms, this law does not merely reduce the tax, it cuts off the funding that allows the tax and the registry built on top of it to function at all. Gun owners have seen tax reductions before. Most recently, the NFA tax was reduced to $0, but that change left the underlying system completely intact. The ATF still processed applications, the registry still existed. The authority to regulate remained untouched. This time is different. The National Firearms Act has always rested on a single constitutional justification: Congress's taxing power, not the Commerce Clause, not public safety, not a general authority to ban weapons. When the Supreme Court reviewed the NFA in United States v. Miller back in 1939, the court did not rule that Congress could prohibit certain firearms, it ruled that Congress could tax them. Every legal defense of the NFA since 1934 has leaned on that same argument: no tax, no enforcement mechanism, no constitutional foundation. And that's where the dominoes start to fall. Federal agencies do not have independent authority. They only act within the powers Congress gives them and within the funds Congress allows them to spend. By defunding NFA tax enforcement, Congress has effectively told the ATF, you may not spend money to administer this system. That means no processing new registrations, no approving transfers, no maintaining tax records, no paying employees to enforce compliance. And that creates a constitutional crisis. Federal courts have consistently ruled that regulations must remain tethered to the constitutional power that justifies them. In NFIB v. Sebelius in 2012, Chief Justice Robert Roberts wrote that the taxing power can only justify regulation if a tax is actually being imposed and enforced. Right now, the ATF is attempting to enforce registration requirements that were justified solely as tax enforcement, after Congress has stripped them of the ability to enforce the tax. That contradiction is not theoretical. It's already being challenged. This didn't come out of nowhere. For years, Second Amendment attorneys and advocacy groups have argued that the NFA registry exists in a legal gray area. The tax was never about revenue. It was about control. The original $200 tax in 1934 was designed to be prohibitively expensive, not fiscally productive. Adjusted for inflation, that tax would be more than $4,500 today. Congress quietly acknowledged that reality when it reduced the tax to $0. And now, with this funding prohibition, lawmakers have taken the next step, whether intentionally or not. Even the Government Accountability Office has reportedly flagged this issue internally, warning that defunding tax enforcement while leaving registration requirements in place creates significant legal vulnerability, and the ATF knows it, which is why within days of the vote, they began preparing their counter-strategy. If courts determine that the registry cannot be enforced under the taxing power anymore, the consequences are enormous. The ATF would lose the legal authority to require registration for suppressors and SBRs, to enforce transfer approvals, to penalize possession based on registry status. In simple terms, the registry would be unenforceable. That doesn't automatically mean suppressors and SBRs become unregulated overnight. But it does mean the federal government would have to find an entirely new constitutional justification to keep the system alive. And that's exactly what they're trying to do right now, because this fight is far from over. In the next part, we're going to break down the ATF's emergency pivot, how they're attempting to shift the entire NFA registry from the taxing power to the Commerce Clause, and why that move could decide the future of federal gun regulation. The ATF is not taking this lying down. Within 48 hours of Congress passing the funding restriction, internal alarm bells went off inside the agency. This wasn't just a policy setback, it was an existential threat. If the courts ruled that the NFA registry could no longer be justified under Congress's taxing power, the ATF would lose its single strongest legal argument for maintaining federal registration of suppressors and short-barreled rifles. So they pivoted. According to internal documents and legal filings that surfaced shortly after the vote, the ATF's legal team began laying the groundwork for a complete constitutional reframing of the National Firearms Act registry. Their goal is simple: keep the registry alive by moving it away from taxation and anchoring it instead to the Commerce Clause. This move is aggressive, risky, and unprecedented at this scale. The ATF's new position goes like this. Even if Congress has prohibited the agency from collecting or enforcing NFA taxes, the federal government still retains the authority to regulate items that move through interstate commerce. Suppressors and short-barreled rifles, the argument goes, are commercial products, manufactured, sold, and transferred across state lines in massive numbers. According to industry data cited in preliminary filings, major manufacturers produce hundreds of thousands of suppressors each year. Roughly 90% of those units cross state lines before reaching consumers. Even home-built firearms rely on parts and materials purchased through interstate commerce. Based on that logic, the ATF claims Congress can still require registration, not as a taxing mechanism, but as a form of commercial regulation. If federal courts accept this reasoning, the registry could survive even without the tax. The forms would look the same. The waiting periods would remain. The database would still exist. Only the justification would change. And that's what makes this moment so dangerous and so important. The Commerce Clause is broad, but it is not unlimited. For nearly a century, the federal government has been careful to justify the NFA specifically under the taxing power. That wasn't an accident. Courts have historically been skeptical of using the Commerce Clause to justify direct firearm registration, especially when the activity in question is intrastate possession rather than interstate sale. The ATF's problem is that the registry doesn't just regulate commerce, it regulates ownership, possession, and manufacture, including items that never cross state lines after creation. That distinction matters. Federal courts have repeatedly ruled that Congress cannot use the Commerce Clause to regulate purely intrastate activity unless it is directly tied to a broader commercial scheme. The more the registry looks like a possession database rather than a sales regulation, the harder it becomes to defend. And that's exactly the argument being made by gun rights organizations right now. Within days of the funding restriction becoming law, a coalition of gun rights organizations launched a coordinated legal offensive. Gun Owners of America, Firearms Policy Coalition, Second Amendment Foundation. Rather than filing a single lawsuit, they filed multiple cases in different federal circuits, all making the same core argument. Without a valid taxing mechanism, the NFA registry is unconstitutional and must be immediately suspended. This wasn't accidental, it was strategic. By filing in multiple circuits, the coalition increases the likelihood of conflicting rulings, what's known as a circuit split, and circuit splits are one of the fastest ways to force the Supreme Court to step in. Their demands are not modest. They are not asking for gradual reform. They are not asking for a transition period. They are asking for immediate nationwide injunctive relief. In plain language, they want federal courts to order the ATF to stop enforcing NFA registration requirements for suppressors and short-barreled rifles across the entire country. Previous challenges to the NFA have failed for one main reason. Courts accepted the taxing power justification. That safety net is gone. The coalition's legal briefs document decades of government statements, court rulings, and agency admissions acknowledging that the registry exists to support tax collection, not commercial oversight. They argue that once Congress defunded tax enforcement, the entire regulatory structure lost its constitutional anchor. And they're not alone. In a move that stunned legal observers, more than 24 state attorneys general filed amicus briefs supporting the challenge. That represents a majority of U.S. states formally telling federal courts that the registry should not be enforced without a valid constitutional basis. That level of state involvement dramatically raises the stakes. But the most powerful pressure isn't coming from lawsuits. It's coming from state legislatures. Several states have begun passing or advancing firearm freedom and sanctuary laws designed to make federal NFA enforcement functionally impossible within their borders. These laws don't nullify federal statutes. Instead, they cut off state cooperation and impose penalties for enforcement actions that violate state law. In practical terms, that means no state or local law enforcement assistance, no shared resources, no facilities, no logistical support. Federal agencies already operate with limited manpower. The NFA registry depends heavily on voluntary compliance and the threat of prosecution. Remove state cooperation, and enforcement collapses. Some states are going even further, criminalizing certain forms of registry enforcement within their borders and authorizing legal defense for residents targeted under federal NFA laws. If enough states adopt these measures, the registry becomes unenforceable in practice, even before the courts rule. The ATF now faces pressure on 3 fronts: a congressional funding cutoff, multiple federal lawsuits challenging constitutional authority, and state-level resistance undermining enforcement. This is not a stable situation, and it's forcing the agency to consider contingency plans that were unthinkable just months ago. For decades, the suppressor and short-barreled rifle market has existed under artificial constraints: long wait times, complex paperwork, legal uncertainty, and a registry that discourages millions of otherwise law-abiding gun owners from ever participating. If the federal courts issue even a temporary injunction shutting down NFA registration enforcement, those constraints disappear overnight. And the firearms industry is already preparing for that possibility. Major suppressor manufacturers are expanding capacity at a pace that makes one thing clear: they believe the registry's days may be numbered. Companies that once treated suppressors as boutique, low-volume products are now positioning them as mainstream firearms accessories. New facilities, expanded tooling, high-volume production lines. Industry analysts estimate that suppressor demand could increase 5 to 8 times if registration requirements are suspended or eliminated. Prices, currently inflated by compliance costs and limited supply, could drop dramatically as competition increases. Today, suppressors commonly retail between several hundred and over $1,000. In a deregulated environment, manufacturers project prices falling into a range comparable to optics or high-end muzzle devices. Short-barreled rifles tell a similar story. Many gun owners avoided SBRs entirely, relying instead on legal workarounds and alternative configurations to avoid registration. If that barrier disappears, manufacturers are ready to introduce factory-built short-barreled platforms designed specifically for a non-registry market. In other words, the industry isn't waiting to see what happens, it's preparing as if change is coming. The ATF understands the implications better than anyone. If registration enforcement is halted, even temporarily, the agency risks losing compliance permanently. Once millions of Americans lawfully acquire suppressors and SBRs without registration, reimposing the system becomes politically, legally, and practically impossible. One strategy focuses on leveraging existing firearm transfer records. While the ATF may be prohibited from enforcing NFA registration, federal firearms licensees are still required to use Form 4473 for all firearm transfers. The agency could issue guidance encouraging dealers to voluntarily annotate transfers involving suppressors or short-barreled rifles. This would not be formal registration, but it would create a shadow paper trail. Through routine compliance inspections, the ATF could reconstruct ownership data for a large percentage of transfers, effectively maintaining a de facto registry without openly requiring one. Another contingency being explored involves reclassification, attempting to regulate suppressors under federal statutes not tied to taxation. These approaches are legally uncertain, politically risky, and likely to trigger immediate litigation. This situation affects current NFA owners more than anyone else, and it places them in an uncomfortable position. There are millions of registered suppressors, short-barreled rifles, and short-barreled shotguns already in the federal registry. If enforcement is suspended or the registry is invalidated, those existing registrations enter a legal gray area. Key questions remain unanswered. Does prior registration still matter? Are interstate transport approvals still required? Can previously registered items be transferred freely? What happens to existing registry data? Right now, there are no definitive answers. Most Second Amendment attorneys are advising caution. Do not rush to make changes based on speculation. Do not assume requirements have disappeared unless and until courts issue clear rulings. If enforcement authority collapses, the legal landscape will shift, but it will take time for guidance to catch up. This uncertainty could last months. The next 3 months are critical. Multiple federal cases are already moving through the courts, all asking for similar relief: an injunction halting enforcement of NFA registration requirements for suppressors and short-barreled rifles. At least one district court ruling is expected soon. If plaintiffs win and the government fails to secure a stay, enforcement could stop while appeals proceed. That scenario would be unprecedented. During that window, suppressors could transfer like ordinary firearms. SBRs could be sold without federal registration. Millions of Americans could legally acquire items previously locked behind the registry. Once that happens, reversing course becomes extraordinarily difficult. The government knows this, advocacy groups know this, the industry knows this. That's why everything is accelerating. There are 3 realistic paths forward. A federal court grants an injunction, appellate courts refuse to stay it, and the registry shuts down while litigation continues. The market opens, compliance collapses, and the system never fully recovers. Courts accept the Commerce Clause argument, uphold the registry under a new justification, and the system survives despite the funding cutoff. Conflicting rulings create a circuit split, forcing the Supreme Court to take the case. That places the future of federal gun registration directly in front of the court, with implications far beyond suppressors and SBRs. This isn't just another lawsuit. This isn't just another regulatory tweak. For the first time in nearly 90 years, the federal government's justification for firearm registration is under direct attack from Congress, the courts, the states, and the public all at once. Whether the registry survives or collapses, the outcome will reshape how firearms are regulated in America. The next 90 days will tell us which direction history goes. If you had to bet, does the registry fall? Does the government adapt and survive? Or does the Supreme Court split the difference? Drop your prediction, stay informed, and stay ready, because whatever happens next will move fast.